Hello students, welcome you all for MBA Semester 3 Human Relations and Legal Framework, Lecture 21. The topic of our today's discussion is Workmen's Compensation Act 1923. Today is our part 3 session and we are going to start this session. The objective of our today's session is helps to understand other various concepts which are being related with the Workmen's Compensation Act 1923. The contents of our today's session are amount of compensation, distribution of compensation, fatal accidents and serious bodily injuries, medical examination, notice and claim, form of application, appointment of commissioner, reference to the commissioner, and procedure in the proceedings before the commissioner, penalties and appeals. So first of all, we are going to start with the amount of compensation that has been described in section 4. So each and every individual workman, those who are working in the industrial enterprise, they are entitled to get the compensation from the employer, okay, unless until there has been some sort of injuries or accidents which are caused due to any kind of hazards or accident to the worker. So it should be specified along with the nature of injuries caused by an accident, okay, how much monthly wages of the workman has been concerned, and the relevant factor, okay, that we will discuss in the last session, okay, that depending on the relevant factor and as well as the percentage loss capacity of that particular individual employee, okay, that should be identified, and depending on that the amount of compensation has been calculated. So there is no distinction between the adult worker or the minor worker, okay. So section 4 will provide the compensation on account of the worker's death, okay, in case of also permanent total disablement, permanent partial disablement, as well as temporary disablement, okay, that may be total temporary disablement or partial temporary disablement. So that amount of compensation has been calculated according to whatever form of percentage loss of earnings, as well as on the basis of that relevant factor which has been specified in the schedule 4 of the act. So let us see some examples, okay, how to calculate the compensation. So compensation for death, okay, the compensation of death has been calculated by means of using 50% of monthly wages into, okay, the relevant factor, okay, divided by 100, or it may be or rupees 80,000, whichever is more. So any of the employees, this is what according to the old rule, okay, that is what the Workers Compensation Act, okay, according to old rule and according to new amendments, the workers compensation has been calculated in this way, okay. So maybe it is the amendment, okay, but that doesn't matter, okay. So in case of death of the any of the employee, okay, so how to calculate the compensation? So that 50% of monthly wages of any deceased employee into relevant factor with corresponding age of the injured person specified in schedule 4, okay, or 1,20,000 rupees of compensation, whichever has been more. Now let us see the example, okay. The person Majuyappa, okay, he is of 35 years, okay, has an accident, okay, during the particular period of employment, and drawing the monthly salary, monthly wages of rupees, say for say, okay, 2,500 rupees. So 50% of the wages, okay, 2,500 rupees is equal to 1,250, okay, and 1,250 into relevant factor, okay, relevant factor for the age at 35 years, okay, has been already given in this problem, okay, 197.06. It may be also located from the table also, okay, that we were seen in the last session. So 1250 into 197.06, okay, which is equal to 2,46,325. That should be a total compensation that should be paid to that particular employee. So in this way we are going to calculate the total amount of compensation during particularly the death of the employee. Similarly, in other cases, okay, the total amount of compensation has been calculated. Some examples that has been given in this today's presentations. Let us see. Say for example, compensation for permanent or total disablement. Now in case of that permanent and total disablement, okay, we will listed out some various forms of disablement which has been caused by an accident. Particularly how to calculate the total amount of compensation. Okay, we are just seeing with the new amendment uh, how to calculate the total compensation of that particular deceased employee. If anybody has been lost any particular suppose say limb or hand or foot, okay, so how to calculate that total compensation in case of permanent total disablement. Okay, this is called as 60% of the monthly employees wages of the monthly employees into relevant factor which corresponding age of the injured workman specified in schedule 4, okay, or 1,40,000 rupees, okay, whichever is more. Okay, particularly in case of permanent total disablement, okay, there will be 60% monthly wages, okay, has been taken into account. Say some example over here. Here the worker Sham, he has attained the age of 35 years, okay, during an accident, okay, he is drawing a monthly wages of rupees 2,500 rupees, okay, and his total compensation can be calculated in this way. 60% of the wages means 2,500 is equal to 1,500 rupees, okay. 1,500 into relevant factor. The relevant factor for the 35 years is 197.06, okay, and therefore the total amount of compensation will be paid to that particular employee Sham is 2,95,590 rupees. So in this way the compensation for permanent total disablement has been calculated. Now uh, uh, in case of permanent partial disablement or even suppose any of the employee caused to death during an accident, okay, according to the notification of the official gazette of that government of India, so any employee those who have been caused to death due to any kind of accidents or hazard, okay, it has been notified to the commissioner, okay, to deposit rupees 5,000 rupees as a funeral benefit to any kind of workman those have been deceased due to accident or hazard, okay, and that funeral expenditure has been given to the dependents, okay, in case of death of the particular employee or to their relatives. So this kind of provisions has been made by the government of India. Then amount of compensation for permanent partial disablement, okay. Now in case of permanent partial disablement, some minor loss would be there to that particular employee. So in case of injury, particularly some smaller type of injuries has been covered, okay, that we will also discuss in part 2 of the schedule 1, okay. So that injury specified in part 2 of the schedule 1 and their percentage loss of earnings has been calculated. Depending on that, okay, the compensation would be paid to that particular employee, okay. So in case of permanent partial disablement, injury specified in part 2 of the schedule 1, such percentage of the compensation would have been payable in case of permanent total disablement is specified therein is being a percentage of loss earning capacity caused by the injury. In other words, the percentage of compensation payable is proportionate to the loss of earnings capacity permanently caused by scheduled injury. Thus the loss of earning capacity caused by injury specified in part 2 of schedule 1 is nearly, suppose say 30%. The amount of compensation shall be 30% of the compensation payable in case of permanent total disablement. If any of the employee who has been caused to any kind of injury which has been specified in part 2 of the schedule 1, okay, say for example any of the injury has been specified in part 2 of the schedule 1, okay, the total loss of earning is suppose say 30%, okay, therefore the amount of compensation that the worker should be liable to get 30% of the compensation, okay, depending on their wages. Now in case of injury, those have not been specified in schedule 1, okay, the percentage loss of compensation payable in case of permanent total disablement is proportionate to the loss of earning capacity, okay, whichever form of injuries which are not covered in schedule 1, okay, schedule 1, okay, in that case its proportionate loss earnings has been calculated and then it should be provided to that particular employee. Now specifically in case of part 2 of the schedule, okay, the part 2 has been specified nearly 48 entries with respect to the injuries, okay. uh, Say for example amputation to the shoulder joints. In case of amputation to the shoulder joints, okay, how to calculate the compensation: 90% of the wages of the particular employee into relevant factor, okay, corresponding to the age, okay, of that injured person specified in schedule 4, okay, depending on that, okay, the total compensation will be calculated, okay, or it should be not more than 1,40,000 rupees. So whichever has been more in case of particularly part 2 of the schedule. So in this way we are going to calculate the compensation of permanent partial disablement. Similarly, in case of compensation for temporary disablement, okay, once any sort of accident would happen in the industry, nearly, okay, half monthly payment would be given as a form of the compensation to that particular employee. So half monthly payment of some, okay, whether a total or partial results equivalent to 25% of the monthly wages from the injury to the workman to be paid in a manner prescribed. So nearly 25% of the monthly wages or half monthly wages in case of total or partial disablement has been provided to any particular employee. Those have been caused to any sort of injuries due to temporary disablement, okay. So this form of compensation has to be provided nearly for not more than 28 days, okay. The employer should have to make the payment on the 16th date of the disablement. So there has been the provision has been made to the employer that how much amount of time has been allocated to make the compensation to that particular employee. The period of disablement lasts for less than 28 days. The payment shall be made after the expiry of 3 days, okay. Once it has been notified by that particular employer, a particular employee, okay, the amount of compensation has been raised to that particular employee, okay, as early as possible, okay, within 28 days. In case of employees makes the any payment to the worker before the payment of half monthly wages every 2 weeks or lump sum amount, okay, it shall be deducted from any lump sum or half monthly payments. So according to section 4 to subsection A, okay, if in case of employer, okay, makes a payment, okay, if the employer is making the payment, so how much amount he will be liable to make as a form of the compensation, either the half monthly wages, okay, or lump sum amount, okay, or 2 weeks lump sum amount should be paid as a form of compensation to that particular employee. Now in case of temporary disablement, okay, whenever we are talking about temporary disablement, exactly temporary disablement has not been covered in this act, okay, but there has been some provision which has been made with respect to the temporary disablement, okay. So employer is liable to reimburse the actual medical expenditure incurred by the employee for the treatment of the injuries caused to during the course of employment. If any of the employee has been caused due to cause any kind of injury due to accidents or hazards, so immediately some sort of benefit has been provided in the form of compensation, okay, and that should be in the form of to meet the actual medical expenditure, okay. So all employers are liable to pay the injured employee with half monthly wages for a period of disablement, okay. Some disablement benefit in the form of medical expenditure has been provided, okay, that should be up to maximum of 5 years. If the employee is not being able to fit to perform the work further, so up till 5 years that medical expenditure will be provided to that particular employee. And some other provisions are being also being there. Okay, half monthly payment referred to in clause D and subsection 1 shall be payable on the 16th day. Okay, so on 16th day minimum half monthly payment will be provided. From the date of disablement, such a disablement shall last for a period of 28 days or more. Okay, if the disablement has been continued till the 28 days. Some other conditions are also being there. After the expiry of the waiting period of 3 days, means after it has been notified by the employee, okay, by means of notice within 3 days, the date of disablement, such disablement lasts for a period of less than 28 days, and thereafter half monthly during the disablement or during a period of 5 years. Okay, so particularly after notifying by the that particular employee, so minimum kind of criteria should be there to provide the disablement. Okay, and that should be half monthly wages has been provided to that particular employee. Some other conditions on ceasing the disablement before the date on which any of the half monthly payment falls due. Okay, if any of the employee those have been not received that particular form of disablement benefit, okay, before the date on which the half monthly payments due falls, okay, there shall be a payable in respect of the half month and some other proportionate duration of the disablement in the half month. Okay, some proportionate amount of wages has been calculated, and that proportionate amount would be delivered to that particular employee as a form of compensation. So in this way there are several provisions has been made in case of temporary disablement. So this has been covered in this way. Now this is called as compensation to be paid when due and penalty by default. Okay, say for example, if any of the employer who has not been provided some sort of compensation to the employee, so that penalty by default has been paid to that particular employee as a form of the compensation. So section 4a has provided some particular form of provision, okay, that is called as payment of compensation and penalty by default. So this will provide the compensation shall be paid as soon as if it fails due. Section 4 mandates the employer to pay the compensation amount as soon as it fails due to victim or his or her legal heirs. If any particular employee those have been not in a position to have any kind of legal heirs, or suppose say he is not having any particular legal provisions to ask for the compensation. Okay, so the provision has been made according to this section 4a, that okay, wherever the employer need to pay some sort of compensation to that particular employee. So compensation under section 4 shall be paid as soon as possible, okay, if it fails due. Okay, so that provisions has been made by that particular employer. However, whether the employer does not accept the liability for compensation to the extent claimant, he shall be bound to make the provisional payment based on the extent of liability which he accept. Okay, there are some certain particular employee those who are being rejecting the claim of the particular employee, they are being immediately directed, okay, by means of using this section 4a, that compensation to be paid when due and penalty for default. Okay, so immediate payment of compensation can be made to the any form of deceased employee those are being suffering from injury or accidents. And other lots of provisions has been made with respect to that penalty by default. Then distribution of compensation. So how to distribute the compensation, which has been covered specifically in section 8, that compensation must be paid to the defendants only. Okay, so no any other person are being entitled to get the compensation on behalf of the any particular employee. Okay, compensation should not be paid directly to the workman. Okay, it should not be directly paid to the workman, because the workman is a deceased employee or the injured employee, okay, are under the treatment, okay, by his employer in case of injury or death. employer should deposit the workman compensation with the commissioner. Okay, so commissioner has been appointed, and accordingly, okay, the compensation will be paid to that particular deceased employee's bank account. Okay, the deposit a compensation to the workman shall be paid through the commissioner to the workman. Okay, all form of compensation in regard to any kind of injuries or on account of death or partial or permanent disablement, okay, all this compensation should be paid to the paid through the commissioners only. If no dependent is there in case of deceased or workman, okay, there is no necessity to pay the compensation by the employer. If there is no dependent, okay, to that particular deceased employee, section 84 will provide the provision that the employer will not be entitled to make the compensation to that deceased persons. If two or more dependents exist for the deceased workman, the compensation shall be distributed by the commissioner according to his wish. According to section 88 and subsection 5, if there are two or more dependents are exist, okay, to that deceased workman, that amount of compensation can be distributed, okay, and the commissioner will decide that. If the workman's dependent is of legal disability, a minor or mental capacity or neglect of the children, the compensation shall be invested for their according to their directions of the commissioner. Now, if suppose any kind of deceased employee who is having any other dependent who is minor, okay, or those whose mental capacity is not up to the mark, or now will not be considered as an adult, okay, according to the law, okay, or neglect of children, in that case, okay, that compensation may whatever the amount of compensation that should be invested in his name, okay, for his future purpose, the decision will be taken by the commissioner. So in this way, the compensation has been distributed, particularly that compensation has been distributed on account of death. Okay, compensation can be payable to the woman or person who is having legal disability, okay, or employer who can have any advance payment directly to the dependent. Okay, sometimes some sort of provisions have been made. Okay, death equivalent or 3 months salary of that particular deceased person can be made as a form of compensation. Employer is exempt from his liability if he deposit the compensation amount with the commissioner within the stipulated time. Okay, if there has been some different form of provisions has been made, the commissioner shall call for a dependent for the deceased or determine the method of distribution of the compensation among them. So how exactly the compensation has been distributed, the commissioner will decide. If no dependents are found, the amount shall be refunded to the employer. If suppose there is no dependent, then what will be the amount of compensation? What okay, the amount of compensation will be refunded to the employer itself only. On request of the employer, the commissioner shall furnish the details of disbursement. Okay, here the commissioner can ask to that particular employee that how does they are fulfilling the criteria to distribute the compensation to the deceased dependents. Then fatal accident. Okay, now accidents which can cause to death of any particular employee, okay, that will be called as fatal accidents. Okay, or this will be also called as the injury, okay, or any kind of damage which can, or injury which can cause to the death of the any particular employee. Similarly, that section 10b will also provide the serious bodily injury which can cause to the particular employee wherever there is a permanent loss of the earning capacity. In that case, that fatal accident and serious bodily injury has been covered in section 10b. So according to section 10a and section 10b, okay, some sort of provisions has been made to investigate the kind of fatal accidents and serious bodily injury. So wherever the commissioner has been appointed, and the employer has to pay the amount of compensation within 30 days of the notice. So there is a minimum period of time, okay, that has been made by the in case of fatal accidents and serious bodily injury. Okay, so here the employee initially receives the notice from the employee. Okay, particularly from the employee side, maybe the dependents can file the suit for that compensation. Okay, and within 7 days the decision would be taken. Okay, if within the 7 days the decision would not be taken, okay, the minimum time which has been prescribed to receive the amount of compensation would be about 30 days. Okay, now these kind of provisions will not be covered under the ESI Act. Okay, so employees those are registered under the ESI, okay, Employee State Insurance Act 1948, okay, to get the compensation by means of using fatal accidents or serious bodily injury, okay, that has been covered only under the the Workers Compensation Act only. Okay, now whatever form of employee which has been caused to any kind of injury due to accidents or hazards, okay, they will be try to appear for the medical examination, and that medical examination facility can be arranged by the employer itself. Okay, qualified medical practitioner will be there. Okay, they will conduct the medical examination and prepare the report and submit the report to the employer. So within 3 days of the notice of the employee, okay, the employer should have to act as immediately as possible, and they need to conduct the medical examination that particular employee. Okay, if there exists any kind of injury, okay, or disablement, okay, the report will be prepared by that medical practitioner and submitted to the employer. The employer will be act accordingly and will pay minimum a half monthly salary as an immediate form of compensation to that particular employee as a form of medical expenditure to that particular employee. So some other provisions has been made with respect to that medical examinations, okay, which has been covered in section 11 2, okay, 11.3 and 11.4. There is a minimum time which has been specified if the inquiry to the employee caused disablement for more than 3 days. In such case, employer is not able to pay any sort of compensation. Okay, so no compensation has been given within 3 days if the injury has not been resulted into the disablement. So there has been some provisions which has been there with respect to the kind of compensation which can be paid to the employee. Notice and claim, okay, whichever form of employee those has been caused to any accidents or injury, okay, they need to notify to the employer that some sort of injuries or accident which has been happened with them, and then they need to report to the employer. Okay, so to claim the compensation, some particular form of procedure has been there. The claimant has to give the notice to the employer, okay, and entering some sort of information in the notice board within a reasonable period of time. Okay, each such notice shall be have been notified with the name of the employee as well as address or person insured or cause of injury or date on which the accident happened. All this information has been written in the notice book, along with some application has been submitted to the commissioner for getting the compensation, okay, within 2 years from the date of accidents. Okay, that provision has been made. In case of occupational disease, okay, the accident is deemed to occur on the first day of the disease. Okay, so particularly in case of occupational disease, okay, if the employee has been found that, okay, there is some difficulty, suppose say in breathing, okay, so they will be immediately notified in the notice book, okay, and simultaneously should report to the employer, okay, and ask for the compensation. Defeat any if any in the notice or not giving notice or delayed application will not bar for the claim of the application. If any kind of employee those have been not been notified, okay, due to whatever form of injury or accident which has been caused to them, or any kind of occupational disease which has been caused to them, okay, in that case, okay, the employee will not be liable to get the compensation. So each and every employee, okay, those who are being looking for to get the compensation, they need to make an application and ask the employer by means of registering in the notice book whatever form of injuries or any kind of occupational disease occur to them. So in that particular register, some other information, name of the injured workman, address of the injured workman, date on which the accident happened, all this information has been written. Now form of application, whichever employee those has been caused to any kind of accidents or occupational disease, okay, they need to make a form of application to the commissioner, particularly to ask for the compensation. Okay, necessary fee has to be paid for the application to the commissioner according to section 22 subsection 2. Okay, that application should consisting of the details of that particular employee, reason of application for the compensation, relief they need, and claim settlement. Okay, what will be the claim settlement amount has been there. Okay, that should be nearly should be provided, okay, along with that application. So along with that, the copy of the notice should also be enclosed. Okay, particularly if suppose any kind of employee those are being illiterate, he or she can take the help of the any person, those particularly to ask for the compensation by means of preparing an application form. So these kind of provisions has been made to ask for the compensation by that particular employee. Now appointment of commissioner. Okay, now the provision has been made by means of the government of India, by means of their official gazette, according to section 20. Okay, so the uh, the uh, the employee should have to make an application to the commissioner to ask for the compensation. Even state governments have been also notified by their official gazette, okay, to distribute the amount of compensation to that particular employee. So whichever form of injuries or accidents which has been caused to any particular employee resulted into any form of disablement, okay, so there will be some mechanism to ask for the compensation using the appointment of the commissioner. Okay, so here the state government and the central government has been notified in their official gazette to appoint the commissioner. Okay, and these employees are being applying to that particular commissioner to ask for the compensation. So reference to the commissioner. Okay, now whenever any kind of employees those who are being suffered from any injury or disablement, okay, they should have to ask for the compensation to the employer, okay, through the commissioners only. Okay, so no civil court matter can be in comes under any kind of jurisdictions of the jurisdiction of the commissioner. So any kind of civil matters could not be entertained by this particular commissioner only. What is the procedure in case of proceeding before the commissioner? Now once it has been once the application has been made by the individual employee for the application, okay, the application has been processed through the commissioner only. The commissioner will investigate the issue, and according to section 19 there will be reference to the commissioner. So they try to investigate the issue with respect to that particular form of compensation. Okay, section 20 there will be appointment of commissioner. Okay, then section 21 venue of the proceeding and transfer. Okay, is it necessary to transfer the case or start the proceedings? Section 22 will cover the form of application. Section 22A will decide the power of the commissioner and require further deposit in case of fatal accident. Okay, if it is necessary to investigate the issue with respect to fatal accidents or some sort of injuries. Section 23 will decide the power and procedure of the commissioner. Section 24 will decide the appearance of the parties, okay, to investigate the issues or particularly to record the evidences. Section 25 will cover the methods of recording the evidences. The issue can be investigated and by means of recording the evidences. Section 26 will decide the cost to that particular form of compensation. Section 27 will cover the power to submit the case. Section 28 will deals with the registration of the agreement if any sort of agreement has been made with the particular employee. Section 29 has been there, effect of failure to the registered agreement. Okay, if the agreement or contract has been followed or not, that should be investigated. So this procedure has been specified to the commissioner. The commissioner will investigate all these matters and conduct the proceedings for compensation in this way. Now there will be some sort of penalties, okay, on account of the compensation which has not been paid. Okay, if the employer fails to maintain the notice book which he or has been required to maintain according to subsection 3 or section 10. Okay, so it is quite necessary to maintain the notice book. Okay, if the employer fails to send the commissioner a statement which he is required to send under the section 1 and section 10a, fails to send the report which he is required to send under section 10b, so some sort of penalties also being there with respect to commissioner also. Fails to make the return which he are required to make under section 16, fails to inform the employee of his right for compensation as required under section 17a. So there will be no prosecution that has been made against the against the proceedings which has been commenced by means of commissioner. Okay, so where an employee is default in paying the compensation due to this act within 1 month from the date it fails due, the commissioner shall direct the employee in addition to the amount of arrears pay simple interest there on the rate of the 12% per annum or on such higher rates. If any of the employer, those who are being liable for paying the compensation but they are rejecting their claims, okay, so they will be directed by the commissioner to pay their compensation within 1 month, okay, or from the date fail due. Okay, so they will be direct the employer to pay the amount of compensation according to their amount of arrears and along with some simple interest, okay, from the rate of 12% per annum or at higher rate. The commissioner will decide what will be the percentage of that total amount of compensation. The commissioner has the power under the act to impose any kind of penalty or the interest on the cleared amount as per the provisions of the act. Okay, here the commissioner has been directed to that particular employer that how much amount of compensation has been paid to that particular employee. Similarly, if the employee has been not satisfied with the proceedings or the amount of compensation that they were received, okay, so they can go to the high court and make an appeal according to section 30. Okay, so according to section 30 the employee can make an application and file a suit under the high court from the following the orders of the commissioner. Okay, so whatever the copy of the award which has been received from the commissioner, okay, according to section 30 the employee, any kind of deceased employee or their dependents can file the suit against that compensation proceeding in the high court, and the high court will proceed that particular proceeding and pay the amount of compensation, whatever the amount of compensation that particular deceased employee and their dependents are liable to that. So in this way the workers compensation will be paid to that particular employee. So that's all about that today's session. Thank you very much.